Welcome back to the Daily Drop. Okay, let's talk implications. So let's say, since the SEC is apparently undefeated, let's say they win again. What are the implications of this outcome for the broader crypto community?
This case really has far-reaching implications for the entire crypto industry. At its core, the case is about the definition of a digital asset and whether cryptocurrencies meet the US government's definition of a security. There are countless companies operating in the crypto space today, many like Ripple, who raised capital by issuing coins and tokens. And if the courts rule in favor of the SEC, virtually all these companies will be involved, in theory, in unregistered securities transactions and offerings, and could be in danger of enforcement action from the SEC. If this were to happen, a host of companies would likely have to adjust their practices and platforms really to fall in line with securities regulation or face stiff consequences.
Okay, so I guess, and you brought up a point that I didn't quite understand before, which is really interesting, right? So, because you're right, the library case has already set a legal precedent, but the Ripple case feels bigger. So, like, do you think that the Ripple case is really the precedent, or they already have it? Like, how high are the stakes regarding this Ripple outcome?
I think you could view it both ways. On the one hand, the SEC, as I mentioned, has an unbeaten record against crypto industry and specifically token issuers, Telegram, Kick, Library, etc. And a determination that XRP is an investment contract is really just another win from that standpoint. On the other hand, the crypto industry arguably views the Ripple case as the last possible defense of the argument that tokens aren't securities. So the outcome of the case, either way, will have a major impact on the psyche of the crypto industry and how the major players view themselves in the context of regulation under the federal securities laws.
Let's talk a little bit about the Howey test, because the way I understand it, the SEC is discerning whether or not a cryptocurrency is a security based on 1940s legislation regarding oranges, which seems a little bit different from cryptocurrency. So why are they using the Howey test?
The beautiful thing about the Howey test is that even though it applies to oranges, it's so tried and tested that it really doesn't matter what the specific underlying asset is. The Howey test is used to determine really whether, as I mentioned, an investment contract exists and therefore security. Now, as you mentioned, it was established by U.S. Supreme Court decision in 1940, and I don't really anticipate the Howey test will be replaced anytime soon. What we've seen is that the existing federal securities laws, the legal precedents, and the regulatory frameworks the SEC has provided, including for the trading and custody of digital asset securities, are really already more than sufficient to properly regulate the crypto industry.
So, okay, look, I'm not a lawyer, although my dad's a lawyer. I don't know if that gives me like a junior lawyer status. But okay, so look, the way I understand the Howey test, it's four basic statements, really, right? It's an investment of money derived from the efforts of others for the purposes of investment, right? For profit. And then it's like a common enterprise, right? This is the language, but it occurs to me, and again, I'm just a layman, that almost anything is going to fail that test, right? It's so broad that of course all the cryptocurrencies are going to fail that test. It seems like it's set up to do that.
Well, I would argue they don't fail it. They meet the qualification of an investment contract under the Howey test. Now, the Howey test specifically says when there's an investment in money in a common enterprise with the expectation of profit derived from the efforts of others, there's an investment contract and therefore there's a security. Put simply, if a person invests money with the goal of a profit, it is very often a security. And the issuer of that security must therefore abide by the federal securities laws when offering that security for sale. Companies like Ripple sold billions of dollars worth of tokens to investors with the goal of using the money raised to build out a network or blockchain. The investors in those tokens invested because they were seeking a profit, and that profit would be derived from the efforts of the engineers, the foundations, the insiders who were responsible for bringing those projects to fruition and generating a return for those token investors. So essentially, really, the only people who are arguing that XRP is not a security, who actually could say that with a straight face, are really those best served by XRP not being a security. But they are really doing so at the expense of their customers and the investment public, because going forward for the industry, the way to end the crypto winter, the way to basically move forward is the clear application of federal securities laws. And I think the Ripple decision will mark a major step in that direction.
I mean, you're such a brain. But look, the only thing I'll say, we're going to go to break. In my view, a lemonade stand also meets all of those criteria for the Howey test. I don't know if the SEC is suing any lemonade stands anytime soon. I got Aaron Kaplan here on the Daily Drop.